Good morning everyone. Fantastic to see so many people in the room and a great energy for what hopefully will be a really informative morning for you all. We're officially on the countdown to 1st of May 2026, and that date matters because it changes how risk sits in the private rented sector. Today is about understanding where that risk is moving and what being ready actually looks like in practice. I'm James Chadburn, Managing Partner at Wilson LLP, and I'll be chairing the session this morning. We've got a strong agenda, so let's get underway. We'll start with Daniel Dixon, looking at the Renters' Rights Act 2025 and what changes first and fastest. Then Lily Hosseini will cover leasehold and freehold reform and why that still matters for landlords and agents. After the break, which will be about 11 o'clock, Rory Lindsay will take us through disrepair, where issues tend to escalate if they're not dealt with early. And finally, Sarah Nielsen will focus on possession and what getting it right looks like in the new landscape. That will take us to about midday. We'll then run a Q&A session on all of the content this morning using Slido as per the QR code that you'll see shortly and which is on each of the tables, or we'll take questions direct from the floor. After that, there will be a networking lunch, and we've got a broad mix of colleagues here representing practice areas from across the firm. So please do take the opportunity to connect. Right, let's get into the first session. I'm pleased to introduce Daniel Dixon. Dan.
Thank you. Good morning. Raising standards in renting. That's what these reforms set out to achieve. I've spent the past decade or so advising landlords and agents on dealing with tenancy disputes. For the last few years, I've been focusing on the various tenancy reforms, starting with the Renters' Rights Bill under the previous government, and now the Renters' Rights Act under this government. There are so many changes coming that I could happily talk about the reforms all day, but I know that risks losing both your patience and also the plans for lunch. So instead, I want to focus on the practical steps that you can take now to try and stay ahead of the curve. As James mentioned, we're going to use Slido throughout the event. So if you've got any questions for any of today's speakers, then please feel free to submit those via the QR codes on your tables. We'll pick up some of the questions after the presentations, and then we'll go through anything more detailed over lunch. So today, I'll start briefly with why the Act was introduced. I'll talk about how the tenancy structures are changing with the move away from fixed terms. After that, I'll turn to possession. With Section 21 being abolished, the Section 8 grounds become the only way to secure possession. I'll focus in particular on the new ground 1A. I think this will be one of the most commonly used grounds in practice. I'll set out the evidence that I believe will be required to satisfy the court, and I'll also look at the penalties that might apply if this ground is used incorrectly. We'll talk about rental arrears, in particular how grounds 8, 10 and 11 work together alongside the changes to notice periods. Whilst on the topic of rent, we'll look at how increases work under the reforms. We'll cover the principles of fair lettings, and we'll look at how landlords and agents should approach pet requests in practice. Finally, I'll give you my view on what all of this is likely to mean for the market. The Act completely resets the model of private renting. We move away from fixed terms and towards open-ended tenancies, where possession is only available under one of the Section 8 grounds. The stated rationale here is to give tenants greater security of tenure, but also more flexibility within the system as well. And whether you agree with the policy direction or not, the practical consequence here is that process matters more than ever. Getting the documentation, evidence, timing, and compliance right will become crucial for landlords and agents. If there's one key takeaway from today, it's that these reforms are designed to reward landlords and agents who raise standards and who get the process right. Now, I'd like to start with a quick poll on Slido, and I'll give you a minute or so to discuss this on your tables first, and if you can pop some answers onto Slido for me. The question is, how many Section 21 notices do you think were served between July 24 and June 25? Okay, so looking through the figures, and thank you very much for your engagement with this, I can see the lowest figure is about 25,000 and then up to 1 million. Well, it's certainly within that range somewhere. And it often feels as though we've served the majority of these as well. Well, I'll give you the figures. Over the 12-month period from July 24 to June 25, more than 30,000 Section 21 notices were served. And of those, roughly 1 in 3 resulted in tenants being evicted from their homes by bailiffs. I cite these figures because they're often relied upon to justify the reforms. Successive governments had committed to what was seen to be an unfair system, one in which tenants could be evicted from their homes through no fault of their own. But in my experience of advising landlords and agents, those figures simply don't tell the whole story. Section 21s were rarely used in practice where there was no fault at all. In reality, landlords tended to prefer Section 21 because the court process was quicker and cheaper. Obtaining possession was seen as less risky, particularly where rent arrears were close to the mandatory threshold, or where there were behaviour issues that were perhaps harder to evidence. But as the case law developed, Section 21 became increasingly technical. There was a far greater emphasis on strict compliance and the service of multiple prescribed documents. And today, a Section 21 claim form runs to over 20 pages. In practice, we routinely see highly technical defences where there appears to be no real prejudice to a tenant at all. These reforms will mean that all possession cases are listed for a hearing. That will inevitably increase both timeframes but also costs. There is already as well, of course, a very significant court backlog. The recent government figures show that the average time from issuing a claim to a landlord obtaining possession of their property is 27 weeks. In larger cities, particularly here in Brighton, but also up in London, those timeframes are often much longer. So what does this mean for all of you? Well, for landlords, the days of quicker, paper-based possession are gone. And frankly, given the backlogs, quicker often just means less slow. Every possession claim will now require robust evidence, which will be scrutinised and tested in court. For agents, my advice is to treat every tenancy file as if it were a court file. And that means documenting everything, keeping clear, comprehensive records of all correspondence with the tenant and copies of any notices that are served as well. So phase 1 comes into effect on the 1st of May, and this introduces 4 major changes to the private rented sector that I want to focus on today. As I've mentioned, Section 21 is abolished. In practice, assured short-hold tenancies are replaced by periodic tenancies. They no longer have a fixed end date, and instead they continue on a rolling basis. The grounds for possession are amended, and some new ones are introduced. Rent increases must now be implemented through the Section 13 process, and the concept of the so-called rent period becomes critical. It determines how and when notices can be served, and it sets the timetable for rent increases. But the Act is being introduced in phases. So phase 1 contains the core tenancy reforms that I've just outlined. Phase 2 follows later this year, and that will introduce a new database for the private rented sector, as well as a new landlord ombudsman. And phase 3 is longer term, and this brings with it the decent homes standard for the private sector, broadly mirroring what we see in social housing. But my session this morning focuses on the practical effect of phase 1. Now it's time for another quick poll, so if you can get Slido open again. And again, I'll give you a minute or so to discuss this amongst yourselves before voting on the answer. The question this time is true or false? Do all ASTs convert to APTs on the 1st of May? Okay, so the majority, 72%, have said true, that all ASTs convert to APTs on the 1st of May. Well, it's certainly true that the vast majority of ASTs do convert, but not all of them. The exception is where a Section 8 or Section 21 notice has been served and is still live on the 1st of May. In those cases, the tenancy doesn't convert until either the possession process is concluded or the notice has lapsed. And I want to correct another common misunderstanding, which is that not every tenancy is an AST. Any remaining Rent Act tenancies, and there are still a few, they remain governed by that legislation, and these reforms don't apply. And there are some other categories of occupation that don't convert either, and these include things like emergency accommodation, many forms of social housing, long leases, student halls, holiday lets, licenses, and also many company lets as well. And I think post-reform, we're going to see an increase in company lets. These are tenancies granted to a company as opposed to an individual, and they fall outside of the assured tenancy regime altogether. I think for some landlords, this might be seen as a way of trying to manage risk and trying to retain that quicker route to possession without satisfying one of the Section 8 grounds. But I don't think it should be seen as a universal solution, because company lets bring their own commercial and regulatory considerations. For example, you'll need to consider whether the company that you're letting to would retain any assets against which a money judgment could be enforced. There's also a risk that the court may simply view the arrangement as a sham if it's not genuinely for corporate occupation. But I think the key practical takeaway here for agents is this. If you manage a mixed portfolio, you must identify precisely what you have, and don't assume that everything is simply an AST. You need to understand the legal status of each tenancy that you manage. Now, for those tenancies that do convert, the rent period must not exceed 1 month. Rent in advance is capped accordingly, and that means that landlords and agents can no longer require several months' rent up front as a condition of granting the tenancy. Tenants can bring the tenancy to an end by giving 2 months' notice. That notice must expire at the end of a rent period, and that's why the rent period becomes so critically important in practice when determining how and when notice can be given. And as I say, the rationale behind these changes is to give tenants far greater flexibility and to avoid them being locked into longer fixed terms. And that was a particular concern where the tenancy wasn't working as intended. For example, where there were unresolved disrepair issues, changes in employment status, or other significant life events. For landlords, what this means is reduced security. Stronger tenant selection at the outset becomes even more important. I think you'll need to intervene earlier on rental arrears or behaviour issues, and you'll need to plan for longer timeframes where a tenant doesn't leave voluntarily. For agents, this has a clear implication for both paperwork and process. I think onboarding documents will require updating, and it's really important to avoid language built around concepts like renewal or fixed term. I think your fee and commission structures will need to be considered. With tenancies on a rolling basis, the traditional renewal cycle disappears. So business models have to move away from renewal fees and more towards ongoing management of the tenancy. Systems will need clear diary points for things like rent cycles, evidence gathering, and compliance checks. And that's the key takeaway here. The tenancy becomes a rolling legal relationship. So, Section 21 comes to an end on the 1st of May. There's still just about time to serve one. From the 1st of May onwards, every possession notice will need to be served under Section 8. For landlords, the biggest change here is that requiring possession now requires a reason to be given. That reason must be clearly set out, supported by evidence, and then ultimately tested in court. This represents a fundamental shift away from the position that many landlords have been used to. For agents, this raises the bar. Detailed knowledge of the possession grounds and careful consideration of how and when notices can be served becomes critical. With no Section 21s, the tenancy file essentially becomes like a court file. So where possession is sought on rental arrears grounds, the court will expect clear, accurate rent schedules, together with a consistent paper trail showing how the arrears have been communicated to the tenant. For behaviour-related grounds, the court will expect to see contemporaneous incident logs, correspondence, photographs, videos, witness evidence from those who are willing to attend court, alongside any relevant police involvement. For other breaches, the court will expect inspection reports, dated photographs, repair records, and clear written warnings to show how the issues have been raised and addressed to the tenant. Now, I fully recognise here that this places a far greater burden on both landlords and agents. The new landscape is more technical, more evidential, and frankly far less forgiving of informal practice. But we're not expecting you to navigate all of that alone. With clear support, proper processes, and early advice, all of those risks can be managed. My fairly sort of simple practical tip here is don't wait for a problem to start before you begin to collate the evidence. Build as you go. Before I move on to my next slide, just by way of a quick show of hands, can I ask who in the room is familiar with the new Section 16E being introduced by the Renters' Rights Act? That's really interesting because I get the sense too this is a provision which has gone completely under the radar. It's actually a really key provision, and it's designed to change behaviour on the part of both landlords and agents. Section 16E requires a landlord or agent to have a reasonable belief that a possession order can be obtained on the ground being relied upon. The intention here is to prevent notices being served speculatively and to force proper consideration before the notice is issued. If a ground is relied upon without this reasonable belief, the local authority has the power to impose a civil penalty, currently up to £7,000 per breach. For landlords, this reinforces the need to take advice much earlier in the process, before notice is served. These reforms no longer tolerate a let's try it and see approach. For agents, this is all about enhanced responsibility and, again, that concept of raising standards. Serving notice without properly checking the relevant ground, any restrictions, the timing, and the supporting evidence becomes higher risk. My advice is to scrutinise any instructions you're given before serving notice, as opposed to simply acting on them. Now, as I mentioned earlier on, I expect the new ground 1A to become one of the most commonly relied upon grounds, and this applies where the landlord intends to sell the property. The notice period is 4 months, but the landlord can't rely upon this ground within the first 12 months of the tenancy, and therefore any decision to sell should be planned well in advance. There must be a genuine intention to sell, and that must be supported by the evidence. And I'm really interested to see how the early case law on this develops, but at this stage, my sense is that the court is going to require some objective material, and that could be a recent valuation or market appraisal. It could be evidence that an estate agent has been instructed. There could be contemporaneous emails or records which show that decision to sell. For a company landlord, that could be board minutes or an internal written resolution. But one important thing to bear in mind here is that once possession is obtained on this basis, the landlord is then prevented from reletting for a period of 12 months. And the consequences for misuse here are significant. If a landlord relies on this ground without that genuine intention to sell and then relets within 12 months, the local authority can again impose a financial penalty, and that's currently up to £30,000. There's also a strategic risk here that I think is sometimes overlooked. Ground 1A is not reversible, and once a landlord commits to the sale route by serving notice, they lose all flexibility. If the sale later falls through, the landlord is then prevented from reletting for 12 months. So this creates a real balancing exercise in practice. Serving notice too early can leave the landlord constrained. Serving too late may risk losing a buyer. I think it's one of those decisions where hindsight is wonderfully unhelpful. Ground 1A, for those reasons, it shouldn't be seen as a replacement for Section 21, nor should it be used simply as a negotiating tool. My practical tip here for landlords is that if you're not ready to instruct estate agents, obtain valuations and see the sale through, then I wouldn't be serving notice at that stage. And of course, both landlords and agents must be mindful of Section 16E that I spoke about earlier on. Serving notice without the reasonable belief that possession could ultimately be obtained now carries regulatory and financial risk. So before I move away from possession, I want to touch on rental arrears. As I mentioned earlier on, many landlords relied upon Section 21 because it was quicker and cheaper, and that was the case even where arrears existed. Ground 8 remains the mandatory ground, but it becomes harder to rely upon under the reforms. For notices that are served after the 1st of May, the tenant must owe at least 3 months' rent where rent is paid monthly, or 13 weeks where it's paid weekly or fortnightly. And that threshold applies both at the date the notice is served, but also at the date of the court hearing as well. Notice periods also increase. So in arrears cases, the current 2-week period becomes 4 weeks, again highlighting the need, the importance of acting sooner. And there are some additional protections for tenants here as well. Any delays in the payment of universal credit must now be disregarded for the purposes of Ground 8. So that means there's no longer enough to look simply at the headline figure. You need to try to understand the underlying cause of the arrears. Grounds 10 and 11 remain available as discretionary. Ground 10 applies where some rent is unpaid, and Ground 11 applies where there's been a persistent delay in paying rent. But because these grounds are discretionary, the court must consider in all of the circumstances whether it's reasonable to make the order. So my sense here for landlords is that the new threshold is harder to reach and easier to lose. My practical tip here is to try and focus on earlier direct engagement. With the changes to universal credit and greater reliance, I imagine, on discretionary grounds, I think the courts will expect to see not just chasing letters, but evidence that landlords or agents have really tried to understand what the cause of the arrears are. But of course that relies upon the tenant responding to that as well. And of course, all of this again sits in the context of the court backlog. With all possession cases now being listed for hearings, I think delays are inevitable. And in my experience in practice, many landlords now take a commercial view. Rather than waiting months for a court hearing, they may prefer to write off some, if not all of the arrears, to try and secure an earlier vacant possession. Now that's far from ideal, but I think it reflects the reality of how these cases are often handled in practice. Now, moving on to Section 13 notices, and this is one of the areas where I think practices really need to change. Under the old regime, landlords and agents had a number of routes to increase the rent. That might have been through a rent review clause, negotiations at renewals, mid-tenancy agreements, or as a last resort, Section 13. All of that flexibility goes away on the 1st of May. From that point onwards, the only lawful way to increase the rent is by serving a Section 13 notice. Any proposed increase can be challenged by a tenant at the tribunal. Once a Section 13 is served, there are effectively 3 potential outcomes. The first is that the tenant accepts the increase or simply does nothing at all, in which case the rent increases on the date set out in the notice. Alternatively, the parties may negotiate and agree a different figure, often lower than what was initially proposed in the notice. Or the third option is that the tenant applies to the tribunal. So for everyone here today, this fundamentally reshapes the rent review process. Informal increases or contractual review clauses are no longer valid. Section 13 becomes the norm. So I'd encourage agents to think in terms of a rent increase evidence pack. So I think the tribunal will be looking for things like comparable listings, historic rents, and any notes of the discussions with the tenant which sit behind the notice. Where a challenge is made by a tenant, the tribunal will determine market rent. But crucially, under the new regime, the tribunal can no longer set a rent higher than what was in the notice. So that removes most of the risk for a tenant in bringing a challenge. Timing also now becomes critical. Any new rent takes effect from the date of the tribunal's decision as opposed to what was set out in the notice. There's no longer any backdating. And that again in practice creates a really strong incentive for tenants to challenge a proposed increase. The government has tried to reassure landlords by introducing a new fee for tenants who wish to apply to the tribunal. That fee is £47. In my view, that's a very modest price for a second opinion on market rent. And in addition to the points about challenges to rent increases, tenants will also be able to apply within the first 6 months of a tenancy, and that's to challenge the initial rent. So that places an even greater importance on getting the starting rent right. Landlords and agents must be able to justify that initial rent by reference to genuine market evidence from day one. So the practical response again here is better process. Earlier engagement with the tenant, a clear disclosure of market evidence, and managing expectations becomes critical. Where a Section 13 notice is served, it should rarely come out of the blue, and I think the strongest cases will be those where the notice reflects what has, at least in substance, already been agreed, and that will hopefully minimise some of the challenges. Pets. This is an area where a lot of confusion is already emerging. Most landlords I speak to are under the impression that they must allow their tenant to keep a pet. And some are already concerned that their one-bedroom flat is going to turn into some kind of safari park. That's simply not the position. Under the Act, the tenant has a right to request a pet. Landlords must respond to that request within 28 days. Landlords can refuse consent, but only where it's reasonable to do so. So my advice here is to document the decision-making process on pets. We can consider whether a refusal is reasonable by reference to several objective factors, such as the suitability of the property, any restrictions in the superior lease, any HMO considerations, or similar objective factors. But what you can't do, because of the Tenant Fees Act, is require any additional payments, and that means no pet fees and no additional deposits beyond the cap. Now, I know that some landlords have attempted to counter this by simply setting the rent higher, but I think that now carries a risk of challenge, and it's on that point I mentioned earlier on where the tenant can apply in the first 6 months to challenge the market rent. I'm intrigued to see how this all works in practice, because in my experience, some tenants will acquire the pet first and then seek consent afterwards, if at all. That, of course, may give rise to possession grounds under the new landscape. And at this stage, I'm not convinced that many of these refusals are actually going to be challenged in court, but I do think that will shift once we see the new ombudsman scheme up and running. At that stage, it will be much easier for tenants to raise these challenges. Now, a final question from me. Let's imagine a scenario, and let's imagine the property is advertised for letting at £1,000 per month. There's lots of demand, lots of viewings. The landlord or agent doesn't encourage any bidding, doesn't invite any higher offers, but nevertheless, a tenant offers £1,250 a month to try and secure the property. The question is, can the landlord accept offers above £1,000 per month? Can I have a quick show of hands for who thinks they can accept higher offers? Okay, a couple of hands at the back there. And who thinks no, they can't accept higher offers? After me, the first. Any don't knows? A couple at the back there, my colleagues. Well, this is a really important change for agents, particularly in high demand areas where scenarios like this arise quite frequently. But under the Act, the vast majority of you are correct, and the higher offer can't be accepted. Rental bidding is prohibited. Landlords and agents must set a clear advertised rent, and they must not accept offers above that figure. And really crucially, it makes no difference at all if the tenant has volunteered the higher figure. Accepting any offer above the advertised rent would still amount to a breach. And if the landlord or agent does accept the higher rent, then once again, the local authority have powers to impose civil penalties. And this would typically start from £5,000 for a first breach up to £30,000 for repeat or more serious offences. But even putting local authority enforcement to one side, there's a second risk here, which I think is often underappreciated. Some landlords or agents may assume that they can avoid the bidding restrictions by simply withdrawing the listing and then re-advertising the property at £1,250 instead. And whilst that might appear, at least on the face of it, to sidestep the bidding rules, it doesn't remove the risk. Because if the property ultimately is then relet at £1,250, the tenant still has that right to apply to the tribunal within the first 6 months on the point of the initial rent. And at that point, the tribunal doesn't care how competitive the market was or how many viewings there were. They ask a much simpler question. What is the open market rent for this property? So I think situations like this will leave landlords and agents with a double exposure. You've got the enforcement risk for the rental bidding restrictions on the one hand, and then frankly the risk that the tribunal reduces the rent anyway on the other. So the key message here for agents is that pricing decisions now matter far more at an early stage. The safest approach is to set the correct market rent from the outset supported by clear, contemporaneous evidence. If a property is underpriced, with the hope that demand can be relied upon to push the rent up, then that now carries a real legal and financial risk, both for you and your landlord client. If I can put it simply, and I quite like this one, price it once, price it properly. If you price it once, price it properly, then you can avoid most of these risks that I've just spoken about. So I'd like to conclude by touching briefly on market impact. First, supply and rent levels. Buy-to-let landlords have already been under significant pressure with changes to stamp duty and sustained higher interest rates. Where landlords choose to exit the market, supply tightens and rents tend to rise. We're seeing that play out in some parts of the country already. Second, a shift in student and seasonal letting behaviour. With open-ended tenancies replacing fixed terms, some tenants may choose to give notice earlier when not tied into longer agreements. That has a knock-on effect for how landlords and agents plan for things like turnover and void periods. In the student sector in particular, I think we may see more properties left empty for longer over the summer. Third, there's the issue of tribunal capacity and rent challenges. I think even with the introduction of the relatively modest application fee, I think we'll see many more challenges to rent increases from the 1st of May, and more challenges to the initial rent as well. And all of that's going to place an additional pressure on a tribunal system where there are delays already, and I think initially that may increase. Fourth, again, the concept of raising standards. In my view, these reforms will widen the gap between landlords and agents who act professionally with robust systems and processes. Evidence, good record keeping, and proactive diary management will become real competitive advantages. And finally, enforcement and local authority powers. Local authorities now have significantly enhanced fining powers against both landlords and agents. And my understanding here is that authorities can now retain a greater proportion of those penalties than previously. I think that may lead to a more active enforcement environment, particularly given the pressures on local authority funding. So whether you agree with the policy direction or not, and I suspect most here probably don't, the market is clearly shifting. Those who adapt early, invest in process, and treat compliance as a core part of tenancy management are far better placed to operate successfully in the new regime. So, to the extent that you haven't done so already, these are the key things that I will be focusing on over the next week or so. Firstly, reviewing all tenancy templates and making sure that they are compliant with the new model. At the same time, review existing portfolios and be clear on exactly what you have, so which tenancies are ASTs, which are not, and which fall into those different categories that I spoke about earlier on. Make sure that you are ready to serve all of the required compliance documents correctly and on time, because process errors now matter more than before. I think this is the moment to tighten evidence systems, particularly around things like rent arrears, inspections, correspondence, record keeping. And staff training here is really critical. Teams need to be comfortable with the new possession grounds, the revised notice periods, and again, the implications of Section 16E in particular. Rent increase practices must be redesigned with a clear, compliant Section 13 process built around proper market evidence. And finally, there's that small window to consider whether any final Section 21 notices need to be served now before the deadline. They can be served before the 1st of May and then issued at court before the end of July. If you take one message from my session today, it's this: preparation now will save time, cost, and risk later on. So, in closing, the Act represents the biggest shift in private renting in decades. From the 1st of May, Section 21 is abolished. Tenancies move to an open-ended, rolling tenancy. Possession can only be sought where there is a reason, and that reason is properly supported by evidence. Rent increases are subject to a much stricter process, and scrutiny starts much earlier at the advertising stage. Now, thank you very much for listening to me this morning. If you have any questions, please do pop those onto Slido. We'll make sure that's back up and running again, and I'll pick up anything more detailed that you have over lunch. For now, I'd like to introduce my colleague, Lily Hassini. Lily is an associate solicitor in our team, and she's going to talk to you about leasehold reforms. Thanks very much.
So where are we with leasehold reform? As Daniel mentioned, I'm Lily and I specialise in leasehold property law. My day-to-day practice involves advising freeholders, leaseholders and managing agents on general leasehold matters. That includes lease extensions and variations, freehold enfranchisement, right to manage and general lease disputes. In this session, we'll be reviewing the Leasehold and Freehold Reform Act 2024, which I'll refer to as LAFRA. We'll explore what's in force under the Act as at today, what we're still waiting on, and what all of this means for you. So to understand the leasehold sector, I pose a question to you. How many leasehold properties do you think there are in England? So if you'd just like to put some guesses on the Slido. So a few more seconds and then we'll have a little look. Right, thank you all. So it looks like we've got a right range from 32 right out to 1 gazillion. So if you were near 4.8 million, you'll be on the right track. Out of these 4.8 million, 41% are privately owned and let in the private rented sector. Therefore, I expect many of you either own or manage a leasehold property. It is therefore important to understand the asset lying behind your lettings, particularly where practices are changing under the Renters' Rights Act. Landlords may be considering their options, whether to stay in the rental market and how to make their income stream more sustainable, or to potentially sell up. We'll therefore look at the options available to you if you have a leasehold property. So what should you consider if you have a leasehold property? Well, option 1, lease extension. If your lease is running short, then you may have to look at extending that. And we'll talk about the marketability of having a short lease later in this presentation. Option 2, right to manage. You may be unhappy with how your block is being run. Perhaps high service charges are eating into your rental incomes and bringing down those yields. So you may wish to consider taking over the management with your co-leaseholders. You'll then be in the driver's seat to arrange the services for your block and hopefully in turn make some savings. Option 3, freehold enfranchisement. This is where you and your co-leaseholders come together to acquire the freehold of your block. Purchasing the freehold has many benefits, and there are 3 that I'd like to explore with you. Firstly, as freeholder, you are in control of the management of your block. Like right to manage, you control the outgoings of your block, and hopefully you can have a bit better control over your overheads as a landlord. Secondly, your leasehold asset is seen to have improved. Your leasehold property now comes with a share in the freehold, and you'll be entitled to extend your lease, say to 999 years, at no premium payable. And thirdly, you'll be in a position to modernise your lease. So again, the question to you, what is the oldest lease start date that you've seen? So if you want to pop some answers on there and see. Okay, so we've had a right few ranges from 21 BC all the way to the 1900s. So I think what we take from this is that a lot of these long leases are pretty old. And in practice, we see some pretty funny clauses like no dancing, no keeping of livestock, and no gramophones. So clearly, quite a lot of these long leases are not in keeping with today's standards. But an interesting point that I'd like to touch on is what Daniel mentioned earlier on the issue of pets. If your long lease prohibits pets, your property may be seen as less attractive, particularly to buy-to-let investors. They will appreciate that the pool of prospective tenants are going to be smaller. Being pet-friendly may be a differentiator in that market. So, by buying the freehold, you are empowered to vary your leases and hopefully improve your asset. I should, however, caveat this. Some landlords in the room may of course welcome a more rigid lease, because if you're not allowed to have a pet in your leasehold property, you can decline a tenant request. So that's something to note. So we've understood the options available to you if you have a leasehold property. But what does LAFRA seek to do? Well, LAFRA seeks to address three long-standing concerns in the leasehold sector. First, the imbalance of power between freeholders and leaseholders. It seeks to make processes more straightforward and empower leaseholders to make certain challenges. Second, transparency. It wants to allow leaseholders to have much greater transparency as to how their buildings are being managed. And thirdly, costs. It's looking to make processes cheaper, both in respect of the lease extension premiums that you pay when extending your lease or potentially buying the freehold, but also on the issue of costs, restricting the level of costs that freeholders can claim back from leaseholders. So what is in force under LAFRA today? Well, not a lot. A common misconception of LAFRA is that it is all in force as at today, but that's simply not the case. LAFRA was designed to be implemented in stages. The three most significant reforms relate to lease extensions and right to manage claims. In respect of lease extensions, since January 25, you are immediately eligible to extend your lease. So if you are viewing short leasehold properties, you can pursue a lease extension from day one of your purchase. As a result of this reform, we've seen transactions proceeding much more smoothly without the need of complicated assignment provisions from outgoing leaseholders to incoming leaseholders, because you control the process from day one. In respect of right to manage claims, since March 25, we're seeing many more buildings being eligible for this route. The non-residential threshold has increased from 25% to 50%. So what this means is if you have a leasehold unit within a block that has a large commercial space, your block may now be eligible for right to manage. Furthermore, freeholders' costs are no longer automatically payable by leaseholders. As a result of this reform, we're seeing leaseholders being more willing to initiate in these claims, and also freeholders more unlikely to make challenges because they know if they want to fight it, they're going to have to pay for it. I ought to note, pursuing a right to manage claim may be of interest to landlords in situations where the wider building is not being properly looked after. We're moving into a market where higher rents need to be justified and tenants have greater challenge rights. Therefore, having oversight and influence over how the building as a whole is being maintained will be important for landlords seeking to protect both their leasehold asset but also their rental income. So what's not in force under LAFRA yet? Well, quite a lot. The most significant reforms we're still waiting on are as follows. First, 9 90-year lease extensions. Currently, your entitlement remains at 90 years for a leasehold flat and 50 years for a leasehold house. Second, The thresholds I spoke about earlier in respect of the right to manage laws remain unchanged for freehold enfranchisement, so many mixed-use blocks still do not qualify for this route. Third, the new valuation rules, particularly the abolition of marriage value. So you may ask, what is marriage value? And put very simply, it's an uplift in the premium that you pay to your freeholder as a result of your lease falling under 80 years. And that's seen as somewhat of a short lease in the industry. So many leaseholders in this pool of people with short leases have been waiting for this reform for a long, long time. Having spoken to valuers, however, there are concerns around this. There are views that to compensate freeholders as a result of losing marriage value, other parts of the valuation formula may need to be pushed up. As a result, those who have leases over 80 years could end up paying more. Again, simply speculation at this stage, but it's something valuers are getting ready for. I'll come on to the next two reforms around service charges and ground rents in my next two slides. So, service charges. What do you think causes the most friction around service charges in blocks? And I would like to hear your thoughts on this via Slido. Too high charges. I'm seeing lack of a solicitor, so hopefully that's where we can come in. Very spenny, value for money, expensive works, management fees. Well, for those concerns, LAFRA does seek to address quite a lot of those. So there are three key themes that LAFRA seeks to introduce around service charges: standardisation, transparency, and greater challenge rights. So in respect to standardisation, we're going to see prescribed forms of service charge demands, future demand notices, and service charge accounts. The aim here is simple: fewer surprises and clearer documents. Second theme is transparency. Leaseholders will have stronger rights to request information about their block. On top of that, freeholders will be required to provide an annual report detailing information about the block. That could be possible budgets, proposed works, and just general information surrounding the block. Administration charges are also moving into the spotlight, with a requirement for these to be clearly disclosed rather than appearing as an unexpected add-on. Greater challenge rights. Insurance commissions are being replaced with transparent insurance handling fees. The fees must reflect the actual work carried out, and the tribunal will have jurisdiction to intervene if that's not the case. Fixed service charges, which have historically been very hard to challenge, are also falling within the tribunal's remit. And finally, litigation costs, and this is a very significant reform. Historically, freeholders have been comfortable with pursuing legal action against leaseholders as they've been more or less been able to recover their costs back from the leaseholders. That is no longer. LAFRA will LAFRA seeks to address this as freeholders' costs will no longer be automatically payable by leaseholders. Leaseholders will also have a right to claim back their costs from the freeholder. So we're seeing a right shift in terms of the position of costs. So I would say that quite a lot of your concerns should be addressed by LAFRA. Ground rent reforms. Well, a topic which is highly in debate. LAFRA introduces two reforms around ground rents. First, when pursuing a statutory lease extension, it introduces a cap of 0.1% of the value of your property. So the intention here is to prevent escalating ground rents from inflating lease extension premiums. Second, LAFRA introduces a brand new right for leaseholders where they can buy out their ground rent only. So this would suit a leaseholder who potentially has a good lease length, they don't need to purchase any more years, but again, they may have escalating ground rents and they want to buy that and reduce that down to a peppercorn. But more recently, and separately to LAFRA, in January 2026, the government published draft legislation dealing with existing ground rents. Their proposals include a cap of £250 per annum, and then after a 40-year period, a cap of a peppercorn, meaning nil. These proposals are not yet law and very well may change before implementation. But taken together, they send a clear message about the direction of travel. The government is increasingly willing to intervene in existing leasehold arrangements. Whether through buyout rights or caps, the era of ground rents being a long-term income stream is clearly being challenged. So, the timetable for LAFRA versus judicial review. Well, freeholders have continued to challenge LAFRA. In summer 25, we saw a judicial review brought by 6 big freeholders. The challenge focused on key elements of LAFRA, notably the abolition of marriage value, ground rent caps, and the cost provisions. Their arguments stemmed on the fact that there was a breach of their Article 1 rights under the European Convention of Human Rights, which protects the peaceful enjoyment of property. At first instance, the High Court dismissed their challenge, finding that the government's approach struck a fair balance between the public interest in reforming the leasehold system and the freeholders' property rights. So, in your view, do you think the challenges made by freeholders are valid or unreasonable? Lovely, thank you. So we're seeing that we're favouring with freeholders in the room. It's interesting to see that. In essence, freeholders are defending their income streams, whilst leaseholders are crying out for reform in a somewhat outdated sector. However, ultimately, I can say that we all share the common frustration around the uncertainty in this sector. We expect it will be months, if not years, until we see any proper movement. The key message here is that freeholders are not going to let this go without a fight. So what does this mean for you? So for the freeholders in the room, you may wish to consider reviewing your portfolios now. Identify assets most exposed to the reforms. Consider encouraging lease extensions under the current statutory framework whilst the valuation rules remain unchanged. Consider being more proactive with any breaches in your blocks, such as non-payment of service charge arrears, whilst the position on litigation costs fall in your favour. At Dean Wilson, we have a dedicated service charge debt collection team, so please do let us know if we can assist. And finally, you need to assess whether disposal of certain ground rent assets is sensible in light of ongoing policy direction. Again, speaking to valuers and auctioneers, the freehold investment market has already taken a dip, but it may be the case that you wish to get out before it takes an even greater dip. So for the leaseholders in the room, you may wish to consider extending your lease now if you're planning to sell or remortgage over the next 12 months. Leases under 80 years are seen as bad security by lenders. So if you're looking to remortgage, you're going to have limited mortgage products available to you. Likewise, if you're looking to sell, you're probably only going to have cash purchases available to you. In any case, take advice early, particularly where your lease term is approaching that 80-year point. We appreciate it's a very uncertain time for you all, so please do speak to us so we can help you navigate your options. So the property managers in the room, you may wish to strengthen your service charge governance now, not later. Ensure your budgets and auditing systems are clear and expect greater scrutiny as the default. Review your insurance arrangements and commissions. Ensure transparency and value for money can be evidenced, and be ready to explain broker selection and cost structures. And improve your document management and response times. Anticipate increased information requests. Ensure your records are up to date and complete, and that those information requests can be responded to properly and promptly. So I've spoken to the different stakeholders in the room, but common takeaways for you all are consider your objectives with your property or your portfolio for the next 12 months. Don't make assumptions or rely on headlines by the government which instill a sense of excitement, hope or fear, or all three. Take professional advice on how your objectives with your property align with the current statutory framework versus the pending reforms, and make well-informed decisions during these uncertain times. Thank you very much for listening. If you have any questions around leasehold reform, please submit those via Slido and I'll be happy to address those during the Q&A. Otherwise, please do come speak to me over lunch. We're now going to take a short break, so pop yourselves to refreshments. We'll then be coming back to listen to my colleague Rory Lindsay on disrepair issues. Thank you very much.
Every housing lawyer regularly has this morning. They turn up at court for a simple possession hearing, well above the mandatory minimum ground, easy on paper. And then at the 11th hour, curveball. The tenant turns up and says, "Judge, I've only not paid because the boiler is broken." Sound familiar? My name is Rory. I'm one of the construction solicitors at Dean Wilson, and my aim is to try and provide clear and digestible advice in an area often fiddled with technicalities. And my title today is From Damp to Damages, a Guide to Disrepair. And I'd like to thank Copilot for the alliteration. Now, my focus today is going to be on short leases. And what I mean by that is leases of less than 7 years. And that does capture most of the ASTs, soon to be APTs, in your portfolios. But some of the contractual principles I'll discuss at the beginning do apply more broadly. I'll look at the current position in law and briefly look at what we might be looking at in phase 3 of the Renters' Rights Act. My key takeaway from today is to treat disrepair early. If you take anything away from today, that is my message. So why is disrepair important for these portfolios? Well, I'm sure most people in this room have dealt with some kind of disrepair claim being raised by a tenant. And the reason you have is because it's the most common defence that we see. The way it works as a shield to possession is that damages can be offset against rental arrears. And if that brings you below the mandatory minimum ground, it can defeat the claim. And it's even more important with the Renters' Rights Act coming in, moving the mandatory ground, as Dan discussed, from 2 months to 3. It can be relevant for discretionary grounds as well. As Dan said, judges have to consider all the circumstances of a case if they're going to grant possession on the discretionary ground, and they're far less likely to do so if there's some historical disrepair issue that's unresolved. It can also void insurance policies that often landlords take out to cover rent and the fees of possession proceedings, because it lowers the prospects of success in obtaining possession below a minimum requirement. Judges must order disrepair damages as a discount of rent. True or false? I'll give you guys a few minutes to go through that. So the answer is false. So the court's role in a disrepair claim, if successful, is to attempt to put the tenant back into the position they would be if not for the breach. However monetarily that's possible. It can be a notional reduction in rent, or it can be a global award for discomfort and inconvenience, or it can be a combination of the two. There's no one-size-fits-all way the damages for disrepair are quantified, but the most common that we see is judges giving a discount in the rent for the time period of the disrepair where the landlord had notice and had failed to fix it. Now, if a property is deemed unfit for human habitation because of disrepair, something I'll go on to in more detail, most or even all of the rent for that period can be discounted, and it's quite commonplace to see judges in the county court doing so. What is disrepair? It might seem like a silly question, but it frames the more complicated questions. Something is in disrepair if it's in a worse physical condition than some earlier time. And in leases, that early time is normally the start of the lease. So determining an earlier time requires evidence from that earlier time. This is why a schedule of conditions between tenancies can be invaluable. A good schedule has photos and clear narratives. It notes the location and type of the building, and it cross-references the terms of the tenancy being entered. It can be the evidential foundation of both a successful claim and defence. Your first port of call is the terms, the wording. Ultimately, leases are contracts, so the wording used governs the parties' obligations and their rights. Legislation only fills the gaps or implies a minimum standard. The key distinction for people in this room to know about is the difference between the words to repair and to keep in repair. Keeping something in repair means that earlier time mentioned in the lease may not be applicable. If the tenant moves in and says, a week in, there's a hole in the roof, the landlord can't say, well, that's always been there. This wording is key also because the implied terms under the Landlord and Tenant Act 1985, which is the key provision to consider with these tenancies, it uses the words keep in repair and good working order in terms of the landlord's obligations. My tip here, when you're looking at the wording, is to consider what, where, who as the starting point. What item is in issue? Where is it in the property? That will often tell you who is responsible as a starting point. For example, brickwork, external, starting point is probably going to be the landlord. However, stain, carpeted room inside could be the tenant. And that's why a schedule of what that carpet looked like at the beginning of the lease could be relevant. So quickly going through the 1985 Act, it applies to the vast majority of these short leases, any granted after 1961. So simple arithmetic will tell you that's the vast majority. It also includes these leases if they have a term of more than 7 years, but includes a break clause of less. So that's not a way to get around the Act, and you cannot contract out of it. The landlord's obligations include the structure and the external, drains, gutters and pipes, supply utilities, sanitation and heating. It also includes any common parts in the building unless they are not owned by the landlord. Now, a common question that we get asked is what standard is actually expected to keep something in repair? Well, it is fact sensitive and it can even require expert evidence. But I think there's two rules of thumb that apply in almost every case. The landlord is entitled to repair the property in the least onerous and cheapest manner, so long as it falls within a reasonable range of repair after it's done. And the second is if something is beyond economic repair, it cannot be fixed, then the landlord must replace it with a like-for-like replacement. There's no need to upgrade unless you're bringing it in line with a statutory minimum requirement. What's worth bearing in mind is you can agree more onerous obligations in the wording. One that we often see in ASTs is good condition. Now, if something needs to be kept in good condition, it implies a certain quality might have to be maintained, not just that it's not in disrepair. So it's always worth thinking when entering into these agreements, is there any benefit for the landlord to go beyond the requirements under the Act? Without a good commercial reason, the Act provides a clear and safe benchmark for the landlord's obligations. So really think about if there is a good reason. Damp. So it's the prime suspect because the majority of disrepair defences and counterclaims that we see stem from damp and or mould caused by damp. And it provides a good example of illustrating the 1985 Act in practice. So let's say something like penetrating damp. Well, that's likely going to be the fault of the brickwork, and it's probably going to be the landlord's responsibility. But something like internal condensation is much more nuanced. That could be caused by, say, a defective boiler causing excess cold. Starting point there under the Act is it's probably going to be the landlord's responsibility. But something like the tenant drying clothes inside in the winter without the heating on and the windows shut, then that condensation could be the tenant's responsibility. Causation is the key element. It's rarely in dispute that there is a defect or a disrepair. It's the cause of it that is the point that people argue over. And that's why it's so important for reports to note the origin. Taking internal condensation that I was illustrating before, a report from an expert noting that the boiler and the ventilation shaft were tested before alleging that the issue is the tenant failing to open windows can take a report from being okay to solid evidence. I'm sure everyone in the room loves a checklist. So these are the defences that you should know about for disrepair claims made under this Act. Disrepair. Is there in fact disrepair? Is something in disrepair? This is probably going to be a point for expert evidence. But if there's no disrepair, then the Act doesn't apply. Access. Is the tenant allowing access on reasonable notice? A landlord cannot fix and investigate what they cannot access. So this also provides a defence. Notice. The landlord's obligations to fix start on notice and a reasonable time frame in order to fix it. So the actual time that the notice is given is relevant and it may provide some form of defence. Fixture. If an item is owned by the tenant and it can be removed at the end of the term, then it might fall outside the scope of the Act. Another property. Is the disrepair issue stemming from another property? For example, it might be a neighbour, or if it's a block of flats, the landlord might be a long leasehold owner. And if that's the case, the freehold might be responsible for the disrepair and resolving it. And that's where you might want to speak to my colleague Lily about the interaction between the AST in place and the long lease. Steps. What reasonable steps have been taken by the landlord? Ultimately, if steps have been taken, reasonable steps, to try and access the property and try and fix it, if the disrepair has not been resolved, but there has been reasonable steps, then that is a defence. And that's why the evidence of the steps being taken can be so vital in these cases. Tenant-like. Has the tenant used the property in a tenant-like manner? I'll go more into what that means, but effectively, is perhaps the tenant at fault for the disrepair? Point to note, under the Act, there is no need for notice to be in writing. It could be effective simply from a routine visit by an agent or a contractor to the property where it's mentioned in passing by the tenant. And that's why I recommend that you have written notice as a contractual term in every AST, what seem to be APT, that is entered. So the Homes Fitness for Human Habitation Act, this is another act to consider. I'm afraid I don't have a catchy acronym like LAFRA. HFHR does not roll off the tongue, unfortunately. And this requires short leases to be fit for human habitation from and during the term of the lease. It's separate and standalone from the Section 11 repair obligations I mentioned earlier. So what is fit for human habitation? Well, it's much broader than Section 11. It's a list of considerations for the core rather than a black and white test. Regard needs to be had for things such as repair, stability, damp, and mould. Regard also needs to be had for the 29 prescribed hazards under the 2004 Act, which fall into Category 1, serious, or Category 2, other. Damp and mould are both Category 1 serious hazards. So for that reason, any complaint about them should be treated as a human habitation issue, not just a routine maintenance. Judges need expert evidence to determine that there is a hazard at the property. True or false? So it is false. This was decided in a case a couple of years ago, Gillians versus Redkite, where the tenant's expert identified mold in a report through photos, but the expert didn't say anything about whether it was a hazard. The landlord argued at trial to the judge that they did not have the expertise to make a finding it was. It's always a bold assertion to say to a judge that they don't have the expertise to make a determination. It's something I would carefully consider. The judge disagreed ultimately and said a hazard is defined in the 2004 Act as a risk to health, not just a measurable result, and so did not need the expert to make that finding, to find it himself. Tenant fault. I've talked a lot about landlord's obligations, but sometimes the issue may be the tenant. Now, generally speaking in law, tenants are required to use the property in a tenant-like manner, and that's during the occupation and when delivering the property back to the landlord. Somewhat of a circular definition, a tenant to use something in a tenant-like manner. And the court has not given us a huge amount of guidance in it, but one judge described it as little jobs that you would expect from a tenant, such as turning off the boiler if you're going away during the winter and unblocking sinks. It is possible to agree clearer obligations within the lease itself, so long as they don't contradict the 1985 Act. And I recommend that there is much clearer wording as to what tenant-like manner in the ASTs that you're entering is. Tenant fault can be relied upon for discretionary grounds of possession. For example, ground 12, is any breach of the lease. And ground 13 is if the condition of the property has deteriorated due to the tenant's neglect or default. And my tip here is to make sure that the terms of your tenancies include a contractual right to damages for a tenant breach. It is a permitted payment under the Tenant Fees Act. So, when a claim lands, what should be considered in the first few days? Notify the insurers. If you've got a policy, the highest chance in obtaining coverage is notifying them as soon as possible. It's often a term within the policy itself. What to record? Well, various different things you could record, but I think key ones are the date and nature of any complaint about disrepair, any inspection findings, and all the communications between landlord, agent, and tenant. Use Scott schedules. Now, this sounds complicated, but it's effectively just a table breakdown used by the court where columns note issues in dispute, the parties' respective positions, and the associated costs. I would make sure that your regular contractors know about this format because it's clear and organised going through the issue in dispute, and it's recognised by the court. So, the agent's shield. These are the things for the agents in the room to be considering. First, review your management agreement. With the changes that are going to be coming in with the Renters' Rights Act and in respect of disrepair, there needs to be clear understanding of the interplay between the management agreement and the AST. The AST is a contract between the tenant and the landlord. The one between the managing agent and the landlord is the management agreement. Because of that, sometimes they overlap, sometimes they don't. So you just want to make sure it's clear whose rights and whose obligations are under those two agreements and whether they align or not. Preserve your records. Emails, WhatsApps, call logs. If you're not sure, keep it. A file gap can be the difference between a successful defence or a costly settlement. A quick note on GDPR. You're entitled to keep your records for as long as they serve a proper purpose. Now, in disrepair claims, the position in terms of limitation before a tenant or landlord can no longer bring a claim, it's a simple contract, it's 6 years. However, if it's been signed as a deed, and that means that the signatures have been witnessed, it's 12 years. And that's how long these records should be kept as a minimum. And my tip here is to use some form of fit-for-purpose tailored software, some property management system that assists in doing these things. Us as lawyers, we have case management systems to keep all of the information that you provide us in a clear and formatted way in a software that's built for us to use. And I'd recommend, if you don't have one, to do so. So, briefly looking at the Renters' Rights Act and the new landscape that may be coming in phase 3. So the government brought in AUAB's law in response to the death of 2-year-old AUAB Ishak, a child who was exposed to mould in his social housing. And as a result, the 1985 Act was amended, first for social landlords, where they have to remedy hazards, and the details of what that means were put in a supplementary regulation. The Renters' Rights Act takes it a step further, and now remedying hazards is also going to be required from private landlords, but we'll need to see the detailed regulations to follow in order to know what that will entail. Whether these regulations will mirror those of the social landlords remains to be seen. The government has said that they recognise differences between social and private landlords, and they plan to consult. It's the government equivalent of saying, watch this space. So just looking at the social housing regulations for a flavour of what we might be looking at, if I was going to guess, it's going to be these key definitions that will overlap between the social housing and the private landlord regulations. So we've got 2 types of relevant hazard, and these are the 29 prescribed hazards under the 2004 Act. And we've got 2 different categories. The first, a significant hazard. Now this is one which relates to damp, mould or fungal growth. It's urgent, but steps do not need to be taken within 24 hours. Whereas emergency hazards, and this can be any of the 29 except issues of inadequacy. Every housing lawyer regularly has this morning. They turn up at court for a simple possession hearing, well above the mandatory minimum ground, easy on paper. And then at the 11th hour, curveball, the tenant turns up and says, "Judge, I've only not paid because the boiler is broken." Sound familiar? My name is Rory. I'm one of the construction solicitors at Dean Wilson, and my aim is to try and provide clear and digestible advice in an area often fiddled with technicalities. And my title today is From Damp to Damages, a Guide to Disrepair. And I'd like to thank Copilot for the alliteration. Now, my focus today is going to be on short leases. And what I mean by that is leases of less than 7 years. And that does capture most of the ASTs, soon to be APTs, in your portfolios. But some of the contractual principles I'll discuss at the beginning do apply more broadly. I'll look at the current position in law and briefly look at what we might be looking at in phase 3 of the Renters' Rights Act. My key takeaway from today is to treat disrepair early. If you take anything away from today, that is my message. So why is disrepair important for these portfolios? Well, I'm sure most people in this room have dealt with some kind of disrepair claim being raised by a tenant. And the reason you have is because it's the most common defence that we see. The way it works as a shield to possession is that damages can be offset against rental arrears. And if that brings you below the mandatory minimum ground, it can defeat the claim. And it's even more important with the Renters' Rights Act coming in, moving the mandatory ground, as Dan discussed, from 2 months to 3.
Thank you, Rory. And thank you also to Daniel and Lily. Before I start, I've got a disclaimer. I'm very excited about the Renters' Rights Act. It's the biggest change we've seen in decades in the landlord and tenant law. And whether you're a landlord, an agent, or working within the legal sector, it will directly affect how you operate. We're all going to feel it. The change is quite significant, but I'm excited because we all get to be part of it. My name is Sarah Nilsson, and I'm a senior paralegal here at Dean Wilson. And just to be clear, that reflects my tenure, not my age. So I can see there are some familiar faces here. I think some of you I would have now been working with for around 7 years. And you will know me well by now that I get very excited about anything to do with landlord and tenant law. Yeah, as you can imagine, probably not the most exciting person at a party. But I do also have another passion, anything Scandinavian. For those of you who don't know, I'm originally from Norway. And as Monty Python put it, I'll forever be pining for the fjords. I like to think of the Renters' Rights Act as a fjord. And you might now be thinking, Sarah, where are you going with this? But bear with me. Depending on where the sun is and the light, parts of the fjord are beautiful, stunning, but other parts will be in darkness and barren. Those landlords and agents with strong records and compliant paperwork will experience the brighter side of that fjord when possession is needed. So today I will be covering phase 2 of the Renters' Rights Act, and I'll also explain a little about our dedicated possession team here at Wilson. Daniel, in his presentation, covered phase 1 of the Renters' Rights Act, and it's clear that phase 1 creates the framework, the end of section 21, the move to a grounds-based system, and new rules around tenancies and rent. Phase 2 of the Renters' Rights Act, however, is less about the legal framework and structure, and far more about compliance and enforcement. It is at phase 2 that I anticipate agents and landlords will feel the big impacts. So, phase 2 introduces 2 major operational changes: the private rented sector database and the landlord ombudsman. Both these will deal with compliance and enforcement, and I will, in my next couple of slides, break these down a little. However, to provide you with some background, the shift towards compliance and enforcement is not coming out of nowhere. Many of you will be aware of the current possession process and all it entails. So we're going to do a little poll, and I want to know your opinion. If you can put your details into Slido. Are courts currently taking a stricter approach to possession claims than they did a few years ago? And then you can perhaps discuss some horror stories amongst yourselves. I think I'll end it there. I don't think it will change much. Absolutely. What we have seen is a clear trend. Judges are scrutinising evidence far more closely. Gas safety, prescribed information, licensing, service. Small technical issues are increasingly enough to derail an otherwise reasonable claim. So the first part of phase 2 is the private rented database. And from late 2026, landlords will be required to register both themselves and their properties onto the private rented sector database. The information the landlord will need to include will be their contact details, information about the property, such as how many bedrooms, is it furnished, and so forth. Safety compliance, so gas safety, EICR, EPC, but also deposit compliance. Tenants will be able to access this information before entering into a tenancy, and local authorities will also have access for enforcement purposes. So as such, the database will bring together key information about the tenancy for landlords, tenants and the council. Demonstrating compliance before the tenancy has even commenced will be absolutely key. There will be an annual fee. We don't know the exact amount yet, it's to be confirmed, but keep an eye on our social media, because as soon as we have that information, we will be posting something interesting on social media about it. The second part of phase 2 is the landlord ombudsman, so not expected until around 2028. And I'm going to take you all back to the fjords. This is a little bit of trivia, and I just can't help myself. The word ombudsman is Norse in origin, so us Scandinavians have now given you ABBA, IKEA meatballs, and the landlord ombudsman. It's literally my two favourite, parts of the world merging together, landlord and tenant law and Scandinavia. But landlords will be required to sign up, and this will introduce a formal complaints route for the private rented sector. Disputes that may previously have gone unresolved, particularly around disrepair, will now have a structured escalation process. And here it's worth to recall what Rory just covered now in his presentation on damp and damages. This is where good records become real protection. Inspection notes, correspondence, and evidence of works carried out will matter more than ever. And indeed, it would be worth taking note from Lily's presentation and consider any superior leases and implications of these to the leaseholder. Again, there will be a fee that the landlord will be required to pay. Hasn't been confirmed yet, but it's expected to be linked to portfolio size. So we're going to have another Slido. I would like to know, at what stage in the possession process are you most likely to instruct solicitors? Okay. Yeah, so a little bit of a split, so half before serving a notice, and I'd absolutely recommend that, and the other half further down in the process. So why does a dedicated possession team department matter? Well, the reality is now that possession is no longer routine. It's evidence-led, technical, carries the real financial risks if it goes wrong. So a specialist possession team sees the same issues repeatedly and can identify problems early, often before they'll become fatal to any claim, reducing risk and costs. And here it would be good to have made notes from Daniel's presentation on section 16E in particular, demonstrating how important it is to have the landlord's legal position checked before serving notice. So what our possession department does, at Dean Wilson, we start with an early and honest review. Where there are issues, we identify them up front. We advise on the strongest route available and recommend any fixes that can realistically be applied to strengthen the claim. We support clients at every stage, from pre-notice advice through to issuing claims and obtaining possession. So how do Dean Wilson differ from other firms? We don't treat possession as a box-ticking exercise. We focus on our clients' objectives and convert those into the most efficient and practical strategies, whether that's formal proceedings or sometimes a more commercial solution. We're based here in Brighton and we have a strong local court knowledge, but we also act nationally. That means we understand processing times, judicial trends, and where delays are likely to be on a national level. We have advocates in all county courts in England and Wales, and they provide us with quite a favourable rate because of our volume instructions. And we also have a streamlined booking portal with high court enforcement, which saves time and costs to our clients when it comes to enforcement. We're upfront on risks and timescales, which agents consistently tell us reduces pressure and complaints their end. Our possession team is led by partners who are recognised in both Chambers and Partners and Legal 500 as leaders in the field of property litigation. We have several solicitors, some of whom you've met today, and around 20 paralegals who are dedicated to possession claims. But most of all, we are a team who genuinely love what we do, and we do it well. So I'm going to finish on a slightly light-hearted note. Which ABBA song do you think best represents the Renters' Rights Act? And I'm quite interested to see what comes out of this. Okay. I mean, you should hopefully all now know me by now. I had to do this. I could not let this one not be included. Okay, so for those of you who have put money, I'm hoping that's towards the council, perhaps, and not towards the listers. Those who have put SOS, I'll be around in the lunch period, and I'll try and save your soul. But I hope that I've ultimately managed to share some of my enthusiasm over to you today. It will be, the Renters' Rights Act will ultimately reward landlords and agents who are organised, compliant and evidence-focused. With the right legal support, this new framework can be navigated, and we're looking forward to doing it together with you. I will now pass over to James, who will just have a quick few words before we have the Q&A session. Thank you.
Thank you, Sarah. Before we move on to the questions, please can I ask you to join me in thanking all of today's speakers. So there's been really good engagement with the Q&A, and I think we've got pretty much 50 questions or so. Keep those coming. The panel will engage with as many of those as they can. And as I said at the break, we're going to produce an FAQ anyway that we will send back to all of the attendees. I think what you've heard this morning is not necessarily about a single piece of legislation. It's about how the balance has shifted. Decisions perhaps that once felt routine now carry more consequence. Evidence matters earlier. Process matters more than ever. And a common thread that I picked up through all of these sessions is preparation, spotting issues early, keeping good records and taking advice before the problems harden. So fewer surprises and therefore better outcomes when things perhaps go astray. So I think we've had a really good set of questions come via Slido. I'm going to hand over to Antonio, a senior paralegal in the team, who's going to take you through those questions with the panel. Thank you very much.
Thank you, James, for the introduction. So as James mentioned, my name is Antonio. I'm a senior paralegal specialising in service charge disputes and recovery. However, today I've been doing something slightly different. I have been managing the Slido. We've had loads of questions through, so thank you to everyone for sending those. Any questions, as James mentioned, that we didn't get through to, we will follow up in a Q&A email. So, bear with me a moment, let me get the questions. Okay, so the first question here is for Daniel, and they've asked, what happens if a sale falls through when using ground 1A?
Well, it's a good question, and it's something which I mentioned briefly earlier on, which is really about the importance of getting timing right. Ground 1A is not reversible, and if you do obtain possession on that ground, and by that we mean a possession order through the courts, then for a period of 12 months running from that order, you can't relet the property, and you can't market it, you can't relet it for any value, monetary value. That applies to short-term lettings as well, so you can't put it on Airbnb, for example. I think the importance here for agents, it really goes back to what I spoke about earlier on, section 16E, and this idea of reasonable belief, and the advice I gave in terms of scrutinising instructions you're given before simply acting on them. So if a landlord comes to you and wants to let their property, the question would be, I think, is it reasonable for you to ask some questions about the background to the property? Has possession been obtained in the last 12 months, for example? That really should form, I think, part of the onboarding process. But I spoke earlier on about the importance of timing with 1A, and it's just that really fine balance of not serving too early and then leaving yourself constrained by not being able to relet, but then also serving too late, factoring in both the notice period for 4 months, but also the court timetable as well. I think, as I say, I'm quite intrigued to see the early case law on this, because the majority of possession hearings, that first hearing tends to be 5 or 10 minutes long. And for those of us who've been to the county court for the possession days, you'll know that we're often in a list of 20 or maybe 30 cases which are listed back to back. If we go into court and we've got the claim form, the particulars of the claim, we've got a witness statement from the landlord setting out their intention to sell, is it going to be decided in 5 minutes? If the tenant turns up and says that's not true, here's some evidence to the contrary, perhaps an email from the landlord which suggests that the real reason for possession was something else, then potentially that could then go to trial, and that's where I think more delay is potentially built into the system as well. But to answer the question in terms of what happens if a sale falls through, it's a case of trying to find another sale, frankly, or waiting for that restricted period to pass before reletting. Otherwise, you've got the risk of the financial penalties that I outlined earlier on.
Thank you, Daniel. So the next question I've got is for Lily in relation to her LAFRA section. So someone has asked, I have a landlord who owns a whole building and all of the flats in between as she owns the freehold. Can you put in place a head lease which does not allow for pets?
Lovely, thank you for your question. So this interplay between superior leases and short-term lettings is something that obviously people are looking into. Well, if you own the freehold, then you're entitled to grant a head lease potentially over the entire block or to the individual units. So potentially you could look to bring in some rules, and one of those could be around pets. But that's on the basis that you don't have existing leases in there, because you wouldn't want to find yourself finding yourself contrary of other leases, under leases. So yeah, if you own the freehold of the block and there's no other interests in that building, then you potentially could look to bring in certain rules, such as a prohibition on pets. But something you'll need to be aware of, under law, you can't grant a lease to yourself. So you may need to switch around the ownership, whether the freehold's owned by you and then the head lease or several different leases are owned by you and someone else or a company. So it's something to be mindful of. Party A can't grant a lease to Party A. You've got to change up the ownership. But yeah, that's something that we could see, is people sort of looking to vary the rules in their building, whether that be to prohibit those. And as I said, some landlords may like a more rigid lease because then they're not obliged to accept pet requests. Or leaseholders coming together to buy their freehold and actually bring that flexibility in their block. So definitely an area up for debate, but there are some options available to you.
That's great. Thank you very much, Lily. So the next question I have here is for Rory. It's in relation to damage and disrepair. Someone has asked, is there anything else in the housing regulations that you think may overlap?
And the social housing regulations?
Yes, in relation to the social housing.
Yes, I mean, there's a lot that could overlap and it is somewhat speculative. If I was going to guess beyond just the definitions, there's requirements to undertake investigations within certain timeframes, and then you have to report the outcome of those investigations to the tenant within a very short period of time, 3 working days, and outlining, is there a hazard, and if so, what steps are going to be taken to resolve it, and if not, the justifiable reasons for determining that there's not. And so I wouldn't be surprised to see those as well. It may just be the timeframes that are different.
Thank you very much, Rory. So this was actually one of our first questions that came through. I originally was going to ask Daniel, but I think it's more appropriate for Sarah. So Sarah, is there a new form of a Section 8 notice?
Yes, there's a draft version that's been published by the government. So it replaces Form 3. And I've had a look at it. It's I think it's just over 10 pages, so it's not a very small, short notice. It seems to have the same fields, or very similar fields to the existing Form 3 or Section 8 notice, and the supplementary paperwork with it sets out that it's still a prescribed form. You still have to complete it correctly, and have all the statutory grounds that you're relying on within the notice. So very similar, but just across 10 pages.
Thank you very much, Sarah. So, a question back for Daniel. A lot of the questions were for him. So I've tried to distribute them fairly. So, Daniel, in relation to the increased number of Section 8s that are going to be filed, what do you expect court timeframes will look like when we're now only using Section 8 over Section 21? Won't this make the whole process longer?
Yes, in short. We lose Section 21s, so we don't have the paper-based possession process any longer. All cases are listed for hearings. As I mentioned a moment ago, the first hearing is 5 minutes long. It's in a block list. So once you get into court and you've done the introductions, you often don't have very long to make your case. And if there's any sign of a dispute of any kind, the courts are only too keen to adjourn. I actually saw an article in the last couple of days about the shortage of judges that we have in our system as well. There are recruitment difficulties in that respect too. So the courts are stretched. I saw this trend begin to emerge really during the pandemic, and I think it's fair to say it's never quite been cleared ever since. There are some courts around the UK that are starting to trial more sort of portal-based documents, so particularly the High Court, which obviously doesn't apply to the majority of possession cases that we see, but in the High Court the process is more streamlined. And I think one of the frustrations of the system nowadays is that you can issue a claim in one part of the country and you might get the documents back within 2 or 3 days and a hearing within 3 or 4 weeks, and likewise the bailiff could be 4 or 5 weeks after the possession order passes. But then down here in Brighton, in London, in the larger cities, the backlogs are much longer, and they're beyond the 27-week average time that I spoke about earlier on. And we discussed this amongst ourselves as a team. We've got a spreadsheet which we record all the different dates on for different courts around the UK. And there are some courts where we're now seeing bailiff dates for the end of this year, start of next, or just the end of this year. Start of next in some courts. Clerkenwell, I think, is probably the worst offender. So I think court backlogs will worsen. I spoke earlier on about my experience of landlords now being, I won't say willing, but they accept the reality, which is that it may well be easier to write off some, if not all of the arrears, in order to get possession more quickly, because they look at the court backlogs, they look at potentially several months worth of missed rental payments, and they think they'd rather get possession sooner so they can relet to hopefully a tenant who does pay the rent. So as a team we've had to think quite creatively about the advice that we give to landlords, not just in terms of the court process, but really how we can try and achieve their objectives and to try and minimise loss ultimately. So no, I do think that court timeframes will in the short term get worse, particularly as we have this bulk of claims being issued before, certainly before Section 21s go away. I think in the medium to longer term, it really depends on how the market reacts to the reforms. It was actually quite telling. I was looking at the questions as they were coming in, and a really common theme actually seems to be, well, is it worth being a landlord anymore because of all these changes? And it goes really to the heart of what I said earlier on about supply and rent levels. And in those parts of the country where I see more landlords coming out of the market, the trend has been that rents have risen. So there's economics at play here as well. But no, I think the court timeframes will certainly get worse in the short term, and then we'll have to see how the market reacts for the medium to long term.
Thank you, Daniel. So that does lead rather nicely into my next question for Lily. On the topic of economics, I'm not sure if this has come from a landlord or a managing agent, but someone has asked, should I get in higher service charges now before LAFRA comes into effect?
Well, the short answer is no. Leaseholders can already challenge variable service charges in the tribunal, so they can already pursue those challenges at the moment. You need to ensure that service charges are demanded in accordance with the lease, and they essentially need to be reasonable. So no, I would not suggest hiking up service charges in view of the upcoming reforms.
Thank you very much, Lily. So the next question I'm going to ask is for Rory. This is another question on damages. So the question is, our tenancy agreement has a clause that says there cannot be no offset. Will this stop damages for disrepair being offset?
In the leases that I was talking about, the short-term leases of 7 years APTs, I doubt it. So Section 12 of the 1985 Act says that effectively if there's a term that in some way provides an immunity to the Act, that the permission of the county court is required to rely on it. And from my experience, judges are rarely willing to do that. If it's some kind of commercial or long lease, it's more likely that it would be relied upon and successful.
That's great. Thank you very much. I am very conscious of the time and the fact the food's about to come out. So I will ask one final question to Daniel. And it was a very common theme. A lot of questions were asked around rent and rent increases. So the one that we've picked is regarding Section 13 rent increases. If you can only increase the rent every 12 months and the tenant challenges an increase to the tribunal, does this mean that the 12-month start is from the tribunal decision or the date of the previous notice?
So in terms of the 12-month period in which rent can be increased, it's 12 months from the last increase. So typically, because of the rules on backdating, that's likely to be from the date of the tribunal's decision. There was something which I noticed in the last week or two, and I didn't speak about it earlier on, but I saw some provisions which have been, again, slightly under the radar, I think, slipped into the Housing Act. It is that there is a provision where if the tribunal does become really heavily backlogged by the amount of appeals, the no backdating provisions can be overturned. So that's the starting point, is that it won't be backdated and it will run from the date of the tribunal's decision. But if that delay ends up being several months, then that might still be overturned at a later date. But effectively, no, the 12 months runs from the date of the last increase. So that's typically going to be the tribunal's decision.
Okay, thank you very much. I can see the food is coming out, so I'll leave it to Daniel to give his final closing comments. Thank you.
Thank you very much. Well, before we wrap up, I want to say a big thank you to everyone here for attending today. And thank you for engaging in the discussions, whether on Slido, with us in the breaks, or at the Q&A at the end as well. The questions that we've seen have been really thoughtful and very much grounded in the practical realities that landlords and agents are now facing. And inevitably, given the amount of changes that are coming, there are quite a few questions that we've not had time to address here today. But as I said earlier on, please do come and speak to any of us over lunch. And likewise, we'll follow up by email in the next week or so with an FAQ sheet to cover those questions which we haven't got round to today. Looking ahead, our intention is to run a similar event later this year. That will give us a chance to reflect on phase 1 and how that's actually bedded in. And we can talk about some of the early practical issues that we've encountered in practice. By that point, we should be able to say with a bit more confidence what's to come in phase 2. So we'll circulate details of that event in due course and very much hope to see many of you there again later on this year. For now, as Antonio said, the food is just coming out, so please do stay for lunch. As I say, all of the speakers will be around, so if you have any further questions for any of us or want to talk through any specific issues, then please do come and grab us. On your tables, you'll see some tote bags. Those have got some guidance notes and material inside them, as well as contact details for all of us. So again, please do reach out to us after the event if you have any further queries. But otherwise, thank you again for coming today and enjoy the rest of your afternoons. Thank you very much.